Okay, as the others are joining us, I'd like to welcome you to today's webinar. My name is Teresa Hatton. I'm the CEO at the Massachusetts Association of Realtors. We're happy to be with you today to provide an update and some recommendations on how to deal with this new home inspection law that takes effect next week. I'm joined today by Justin Davidson, our General Counsel and Director of Government Affairs. Justin and his team have been working on this law and regulation for several years now. So we are at the point of launch date. We can give you a little background history on how this happened. In fact, I'll start by doing that. But before I kick off, let me just say that this is being recorded. So if you have to jump off, or if you want to come back and replay certain questions or answers, it'll be available on our website on the home inspection page tomorrow. If not sooner, but definitely by tomorrow, by the time we download it, edit it, and upload it again. Also, the Q&A is open. Please use the Q&A if you have any questions. When we did a webinar earlier this year, there were over 500 questions, and it was challenging to respond to all of them. So we will do our best either in writing or verbally here. And if we don't get to your question during this webinar, we will be downloading all of the questions after and adding it to our website. There is a Q&A section already up there. I highly recommend you check that out as well. And with that, let's talk about why are we here today? For those of you who were selling real estate back during COVID, if you'll remember, it was very challenging to get lots of people in and out of houses for showings. It was a very high demand period of time in the market with little inventory, decent interest rates still, and a large demand of people who were looking a lot so to move out of the city or move out of other places and have their own space. So very high demand. What a lot of individuals decided to do to make their offers more competitive was to waive their home inspection as part of their offer. Again, it was a unique moment in time where going in and out of properties was challenging, both scheduling, health concerns, etc. So that happened, and then a lot of people after they got into the home wish they had done home inspections. And this came up through constituents complaining to their legislators about, I really should have done that. I'm not sure why I waived it. So the elected officials heard this from their constituents and said, what can we do to try and remedy this? Now, the market has already remedied this for the most part this year. However, we have this regulation in place and it is here and it is here to stay and it is starting next week. So what is this regulation? The regulation says that the buyer has a right to inspect the property. Okay, that is what this is all about. And how do we comply with that? The seller is required to sign a disclosure and present it to the buyer and say, you have the right to inspect this property. Now, the terms of all of this, Justin's going to go into all of the details, and I am going to focus on the Q&A, and that's how we are tag teaming our session this morning. So thanks for letting me give sort of the intro of how we got here, and now Justin's going to go with, we're here, how do we move forward? So with that, thank you, and Justin, take it away.
Thank you, Teresa. And I love the way you break that down. You know, when you look at this law, yes, there are a lot of details that we are going to get into, but it really is distills down to that simple idea that a buyer has the right to inspect a property before being bound by a contract to purchase it. And the seller has to provide a disclosure and cannot make the acceptance of an offer contingent on a buyer waiving a home inspection. So that's what it is. But here are some things that you as realtors need to know about the law. Teresa mentioned it goes into effect for contracts entered into on October 16th and after. So now's the time to make sure that you're familiar with it. If we don't get to a question that you have, make sure you drop that in the Q&A. But the law does require the seller to provide that disclosure to potential buyers, notifying them of their right to have the home inspected. We're going to go over exactly what is in that disclosure. It really operates more as a notice, but failure to provide that disclosure is going to be a strict liability violation of 93A. You all are familiar with 93A, the Massachusetts Consumer Protection Law, and the damages that that can bring, which is triple damages as well as attorney's fees. So make sure in every transaction that you are using that disclosure. The disclosure is a state issued form. So the Executive Office of Housing and Livable Communities just came out with the final draft of that disclosure last week, and it should be showing up in all of your forms platforms if it's not there already. It's also on our website, also on the state's website, so available for you. As I said, this has to be completed before the buyer and seller enter into a contract to purchase the home. And then one final thing comes up quite frequently in these types of discussions. This does not require the seller to renegotiate based on the findings of the home inspection. If the buyer has a home inspection, they have a contingency. They can walk away from the transaction, but the seller doesn't have to agree to either make any changes to the home or renegotiate any terms of the agreement. Some additional details here. This does only apply to the residential purchase of 1 to 4 units. So if it's an individual condominium unit, then it will apply. If you are buying a 5-unit multifamily home, then it doesn't apply. And that's because in Massachusetts, generally anything over 4 units is viewed as commercial. So they wanted to focus on protecting consumers in Massachusetts that are buying those 1 to 4 unit buildings. The time period to conduct the home inspection for the buyer is going to be reasonable. The buyer is going to be able to set it, but it must be a reasonable amount of time. And we'll talk about a bit about what is reasonable and how the facts and circumstances can affect what is reasonable and what would be unreasonable. Now, I'll say it here and it'll come up again, but the buyer does not have to conduct an inspection. This is not a mandatory home inspection law. This is a mandatory opportunity for a buyer to have a home inspection. So the buyer can't waive their right to a home inspection until after their offer is accepted. And that's really important. The buyer has to have that right to have the inspection, and they can't do or say or write anything that would limit that in advance of their offer being accepted. And as I mentioned here, it does apply to contracts that are entered into on October 16th and after. So as we get to, actually first, we'll talk about what is a home inspection. So when the state develops laws and regulations, they need to make sure that they are defining key terms. And how they've defined a home inspection here is in accordance with the standards of practice for Massachusetts licensed home inspectors. So it's going to include things like checking the roofing, the exterior, the structure of the home, the electrical, the plumbing, heating and cooling, sort of the general condition of the interior and insulation that is readily accessible to them. What you might notice is that this doesn't include common inspections such as radon or pest inspections, inspections for energy efficiency matters. And that's going to be important when we talk about MAR's new contract to purchase. So keep that in mind as we head there. There are limited exclusions to the law, and we'll talk about them here. Really, the first one on the screen is the one that's going to be most relevant for you all. And that is new construction, but it is only new construction where the contract is entered into prior to substantial completion, and it must include a 1-year builder's warranty. So substantial completion means the time when the construction is sufficiently complete so that the residential dwelling unit may be occupied, whether or not a certificate of occupancy has been issued by the city or town. So really, when you think about that, that is, there's not much to inspect. It's either the buyer is buying the lot and an agreement to build a house, or maybe there's some construction of the house done, but there's really not enough there to inspect. Once you've hit that substantial completion part, that's when a home inspector can actually come in and review the items that we just talked about on the previous slide. So I would urge caution here. Don't try and push this. It is only for contracts entered into prior to that substantial completion. So if it starts to feel like the house is substantially complete, then don't try to use this exclusion. All of the other exclusions fall into this sort of non-arm's length transaction, right? These are transactions that are not going out onto the open market, and that's sales because of a divorce proceeding. It's sales for estate planning purposes and sales due to transfers due to foreclosure. So when you look at, we'll go back to estate planning purposes because I want to make clear that this is not for an estate sale, right? Because an estate sale, it is going out onto the open market, but it's when the property is transferred to a relative for estate planning purposes. So that could include things like a revocable or irrevocable trust, where at least one of the beneficiaries is a relative of the seller. And then the regulations do define relative in a far broader way. So keep those in mind, and that's important because the disclosure is going to reference the exclusions, but not list them out. So I just want you all to understand that really, if you are involved in the transaction, it is unlikely that an exclusion is going to apply unless it's that new construction one. Important to touch on what's not allowed as we get ready to talk about the contracts and forms and how transactions will work. And it is really anything, the regulations say anything that would render a home inspection meaningless. And I think there are some examples to use here. The first being that, the buyer has preserved their right to have a home inspection and the contingency with it in their contract to purchase. Say they have 7 days to do it, and then the seller boards up the house and doesn't provide them access, right? Well, that home inspection is now meaningless because they haven't had access to the systems of the house, been able to have a full, clear home inspection. Also, if there's anything in the language that would essentially prohibit the buyer from choosing not to go forward with the transaction if the results of the home inspection are not satisfactory to them. So what does that mean? If they had to forfeit their entire deposit and, or requiring in a negotiation that a buyer have a real substantial deposit that they'd have to walk away from. Well, now you've made it so much that regardless of the results of the home inspection, the buyer's going to have to go through or suffer really catastrophic financial harm. So that's where you have to be careful with the terms in the contract, and hopefully our contract to purchase will make that easy for you. Now, what is allowed? The state and their regulations do allow a buyer to indicate that their home inspection contingency is only triggered if the home inspection report identifies enough repairs that the estimates would exceed a given number. So maybe it's $5,000. This is a way for a buyer to indicate that they are a serious buyer and they're not going to use the home inspection report to walk away for sort of those insignificant findings that sometimes show up in those reports. Now, this does have to be a reasonable number, right? On the sale of a $500,000 house, this can't be $100,000. That's unlikely to hit that point, which would render, again, that home inspection meaningless. So I know reasonableness, it can be a tricky thing. It is used in the law, often a reasonable person standard, but here, you're going to have to think, and if it hits you and you think, well, that doesn't seem reasonable, I think you all will be the ones to be able to identify that quicker than anyone else. So now we're going to head into our forms updates. So we've updated our contract to purchase, the home inspection clause contained there. That carries over to our purchase and sale agreement. We also have a post-contract termination of inspection rights addendum. And what we're going to do is start with the state's disclosure form. So you can see it here, tough to read. So I encourage you to visit our website and take a look at our home inspection webpage and download the disclosure there so you can view it right up front, but it reviews the law that is now in place. It has the seller's disclosure where they say they're not going to make the acceptance of the offer contingent on the buyer waiving a home inspection. It's the buyer's acknowledgement that they understand that they have the right to have the home inspected. And then it has a box for the property address. I know you all are looking at this right now and saying, well, where are the signature lines? And I'll tell you, if we tried to put the signature lines on, you wouldn't be able to tell what you were looking at. I think it's hard enough here with the small text. So trust me when I say below the property address, you're going to see 2 lines for signatures for the seller, 2 lines for signatures from the buyer, and then a final line for signature of the listing agent. Now, it only includes the listing agent because the law puts the onus on the seller to provide the state disclosure. So the listing agent will have to sign. If there is no listing agent involved, there is a checkbox at the bottom of the page to indicate that there was in fact no listing agent involved, and that's why there's no signature there. The seller, listing agent can, and I think it's probably best practice, is to upload this into the MLS as part of the listing package. Have your seller sign this with the property address in it, include it with the listing so that any potential buyers working with a buyer agent can pull that from the MLS and sign it in advance of any contract negotiations. Now, I'm going to just say it again, this has to be completed before the offer is accepted. So what that means is a buyer can submit this with their offer so long as it's already been signed by the seller. So in their offer package, they can include their offer signed by the buyer, as well as the disclosure fully signed by the seller, by the buyer, and the listing agent. Say it one more time here, failure to use this form by a real estate agent is 93A strict liability. So this is really, the state is looking at real estate agents as the ones to make sure that this disclosure is used. And we do, it's called a disclosure, but really it is just putting all parties on notice of the law and what their rights and limitations are under the law. Our contract to purchase, our forms content advisory committee spent a great amount of time working through the changes, discussing how best to implement them in our contract to purchase. And I think there are really 3 key things that need to be addressed under the new law. The first is, what is a home inspection? The second question is, when will the home inspection occur? And the third is, what is the contingency trigger? So if a buyer has their home inspection, how is that contingency triggered? And we're going to walk through each one of those right now, and you'll see the language from our new forms at the top for each part that we're discussing. At this point, you should see all of the new forms labeled new in your forms catalogs. So make sure you take a look at them, familiarize yourself with them, but here's just a quick overview. And you'll see we're going to start off with what is a home inspection. And earlier we talked about how the law defines a home inspection, and that it covered those identified parts because that's how a home inspection is defined in the home inspector's standards of practice. So the state says a home inspection, and you'll see here a home inspection in accordance with 760 CMR 74. That is the regulatory site to the new law. So it has to cover those components, be conducted by a licensed Massachusetts home inspector, and include that written report at its conclusion. The MAR form also includes, it has that language, including but not limited to pest, radon, lead paint, energy usage, septic, sewer, water quality, water drainage. So those are just some of the examples of what a buyer would be able to do for inspections under the MAR form. So this is more expansive than the law. This is actually very similar to the language that is already included in the MAR contract to purchase. So if you're familiar with that, this really carried that over and just adding the home inspection in accordance with language. The forms committee, as they reviewed this and debated how to handle it, really thought that this was the best way to move forward because it's how many consumers and really real estate agents think about what a home inspection includes. So, if you think you're walking through with a buyer, they have a home inspection, they might also want to have a radon inspection, and this allows them to do so. The next question, I think, is the easiest one, is when is the home inspection? And you'll see here, all you have to do is insert that date. And this is a date that will give the buyer a reasonable amount of time to conduct their inspections. So as I said, we're going to touch more on reasonable and what is not reasonable, but think about your market and the home inspectors that you work with. Are they available on 3 days notice, 5 days notice, 7 days notice? Make sure that the buyer has enough time to actually get a home inspector in there to inspect the home, provide that written report, and then the buyer is going to have until 5 p.m. on the calendar day after this date that you've put in here to notify the seller if they are going to withdraw under the contingency in the contract. So think about that, right? Is it possible to get a home inspector in 2 days? Maybe. Is it possible to get them in 7 days? Most likely. And that's where we're going to see that reasonableness. So finally, on this one, what triggers the contingency? And you'll see the language here, and this is new to MAR's contract to purchase. Currently, I will say, because our contract to purchase is still live, it would say that the buyer can withdraw from the transaction if the results of the transaction are not satisfactory to the buyer in the buyer's sole discretion. And that means for any reason identified in the home inspection report. If the buyer is not happy with anything in that report, they could withdraw from the transaction and get their deposit back. What we've done is included, and we referenced this earlier, that the state, through the regulations, has allowed for this estimated aggregate cost of repairs identified in the home inspection. So the buyer can say that instead of at their sole discretion, and importantly, this is a choose one, and you see that right there in the language, in the parentheses, choose one. So it's either the buyer's sole discretion or if the aggregate cost of repairs exceeds a given number. And again, this has to be a reasonable number. It can't be something that would basically prevent the buyer from walking away, putting that number at such a high amount that there would never be enough repairs to justify that cost. So that is the final piece. Again, an either or. Make sure that if your buyer is using that estimated cost of repairs, that it is a reasonable amount. Also note, you can't ask a home inspector to provide an estimate. So this will need to be done by a consultant regularly in the business of providing such repairs or improvements, so it does have to be in writing so that you can provide that to the seller to trigger that contingency. These changes are all carried over into our purchase and sale, so I'm not going to review them again, but just know that the language is in the purchase and sale as well. And then we have finally this post-contract termination of inspection rights addendum. This is what you would use if you are working with a buyer who has preserved in their contract to purchase those, we'll say 7 days to have a home inspection to comply with the law, but they know they're going to do substantial renovation to the home. They don't want to have it inspected before they do that work. It's not going to tell them anything that they need to know before that work. This allows a buyer to move faster to the purchase and sale stage so they can notify the seller that even though they have the right to have the home inspected under the new law, that they are in fact choosing not to have it inspected. And it builds in some protections for you all as buyer's agents to release any claims against the buyer broker if they later discover problems with the house that would have been uncovered through a home inspection. So again, this is something I don't know really how often you'll be using this, but it is here for those limited circumstances where you have a buyer who knows that they're not going to have the home inspected. Now, I want to stress this again. This can only be used after there is an accepted contract. And I sometimes get the question, well, can we provide it as soon as immediately after the contract is accepted? Uh, it can be provided anytime after acceptance. I would urge you all to work with your buyers and make sure that that is in fact how they want to move forward, because they have preserved this right to have the inspection. So, make sure they're not rushing into waiving it after the acceptance. And I've talked a lot about reasonableness, and that's because it's the language that the state has used in the regulations. And I think one of the things I've seen from others is using this sort of red, yellow, green approach to what is reasonable. And we'll use examples of the dates to conduct the home inspection, right? If you get that offer and it says the buyer is going to have 7 to 10 days or more to conduct a home inspection, that's your green light, right? That seems on its face to be reasonable. Maybe if for some reason in your market that's not reasonable, you'll know that. But for the examples here, that would give the buyer enough time to get a licensed home inspector in there to inspect the home and provide that written report. You can kind of just move forward, right? You don't need to do anything. You start seeing less than that, right? It's in that like 4 to 6 day window. Maybe in your market, that can be tough to get a home inspector in there that fast. That's where you stop and you're going to check with, your manager, your broker, say, this came in, seems a little fast based on what I've seen. What have you heard that, are people able to get home inspectors in? So kind of just proceed with caution. Anything less than that, right? The offer comes in and it says, we're going to have a home inspection conducted within 48 hours, within 2 days. That's where you need to stop, check with your manager, your broker, say, I just got this one. This seems unreasonable. And also reach out to the buyer agent, right? Make sure you're having communication with the buyer agent and say, hey, we've got your offer, but it says you're going to have a home inspection in 2 days. That doesn't seem possible. The buyer agent, and I know some of you are out there right now, might say, no, I've got a list of home inspectors that are available on 1 day notice, so they can get in and get it done. So this is reasonable, right? You just want to make sure that you're stopping and making sure that you understand all of the facts and circumstances involved in that one to make that judgment call of whether or not it is reasonable. So I hope you find that helpful. And I think, Teresa, we can open it up to some questions now.
Absolutely. And thank you, everyone. There's several common themes, one of which Justin did highlight, but it covers probably 30 questions. Can this form be signed by these sellers and uploaded into the MLS as an attached document? The answer is absolutely, positively yes. That is probably the most efficient way to do that. My caveat with that is that will help you as the seller's agent. However, if the buyers are coming unrepresented, or if the buyers are coming with a licensee that is not affiliated with that multiple listing service and does not have access to those documents, the seller is still going to have to present that disclosure before an offer is made. So please keep that in mind. But yes, that probably in 90% of the situations will cover you. So please use that as an efficient way of communication. There are also a lot of questions about existing listings that are out there now. So what happens next week? If you have, and Justin, jump in and correct me if you think differently, but if you have an offer presented and everything's tied up before the 15th, you keep moving forward. If you don't have offers and you receive an offer on October 17th for a listing that was taken September 1st, this applies. The trigger date is the offer, not the listing date, which is so different from how we think about our transactions and what needs to get done when. But yeah, the trigger date here is the offer date. Justin, do you want to elaborate on that at all?
No, you covered it well. It's the date that the contract is entered into. So anything 16th and after, make sure you are using the disclosure and following the new law.
Um, a lot of questions about, and I'm going to try and combine two or three of these questions into one because they each had similar things but different nuances. A buyer can still waive a home inspection, yay or nay?
Not in advance of the offer. So
Thank you.
in the
All right,
offer,
I think Justin answered three different questions in one way. Again, the key is the offer in this regulation. So go ahead and elaborate, Justin, and I'll find some others.
yeah, and I think one of the things I missed as we were going over the contract to purchase, our old contingency had a parenthetical that said delete if waived, because the buyer could waive it. That's gone. Right now, the home inspection contingency is a key term of the offer. It needs to be in the contract to purchase so that the parties understand how that transaction will move forward. So just keep in mind that it's there. Don't try to strike it out. It is a required component of the contract.
Awesome, thank you. Um, Emma asked a question that I love, and I'm excited for you to answer this. At one point, I remember seeing home inspectors being exempt from this. Is that the case?
That is not the case. That was in the original draft of the regulations. Provided some real concerns to us and to how that would be handled, right? We shouldn't have exemptions to a law based on an occupation. So yeah, home inspectors are not excluded. Investors, contractors, they all have to follow the law. They don't then have to have a home inspection. They can choose not to have a home inspection, but they have to follow the law and they are not excluded.
A lot of questions about lead paint form and this regulation. They are not the same.
Correct. They are not. They are two separate laws, but our inspection language does include lead because lead is not a required component of Massachusetts home inspection. So you still have the lead disclosure requirement and the inspection requirement as well.
Okay, great. A lot of questions about FISBOs. I remember you answered that, but since we're getting more, if you wouldn't just, and I did put in the comments, we have a section on our website for home buyers and sellers related to this regulation and the FAQs. If you're representing a buyer with a for sale by owner, feel free to share those links with the seller if they are not aware of this regulation. The Massachusetts website at mass.gov also has information about this regulation and the form. You might have to educate that home seller that this is a requirement.
Yeah, so the law does apply to sellers as well. So the requirement is on sellers and their agent to provide the disclosure. And the buyers and sellers have to follow the law as well. So yeah, even on a FISBO, if you're representing a buyer and there is no listing agent, I would encourage you to make sure that the disclosure is provided to both parties. But again, you'll check the box at the bottom that there is no listing agent involved.
There's a lot of questions about why doesn't the buyer's agent have to sign this form as well? And for those of you who didn't link to the actual form, it's the sellers, the buyers, and then the seller's agent, unless there isn't one.
Yeah,
Why?
and
Curiosity. Why not the
it's
buyer's agent?
a great question. It's because, again, the state has put the onus on the seller and their agent to provide the disclosure. So the buyer agent certainly involved in the transaction and needs to educate their buyer of their rights under the law. They just don't have to sign the disclosure because, again, it's the requirement is that the seller is providing the buyer with the disclosure. Teresa, I'll touch on another one that
Great, thank you, because
um,
I'm having a hard time keeping up with the 300 that we're up to.
I thought that might be the case, but the question on pre-inspections comes up a lot, and I meant to address it earlier. So I will tell you, if it is the seller having an inspection of their property done in advance of listing, it's not going to satisfy the law, even if it is conducted by a licensed home inspector in accordance with the standards of practice. And that's because it is not done by an inspector of the buyer's choosing. So the key here is that the buyer has to be able to choose the inspector that is inspecting the house. So what if a buyer has a pre-offer inspection conducted by a licensed Massachusetts home inspector of their choosing with a written report at the end? They can do that. There's nothing in the law that prohibits them from doing so. Obviously, they have to have permission from the seller in order to gain access to the house in advance of their offer. And then in that case, right, this is one of those limited circumstances where the buyer might say, I only need a day or two to conduct any additional inspections because I've already had a home inspection conducted by a home inspector of my choosing. And here's where you have to look a bit at the intent of the law, right? The intent of the law was to protect consumers, buyers, making sure that they've had an opportunity to have the home inspected. Here, that's been done. It's just been done in advance of the offer. So yes, it can still be done, but no, they cannot then waive the contingency. They'd still include that contingency in their offer, but maybe with a shorter period of days on it.
We have a question about, are buyers now going to be required to do radon and pest inspections? And related to this, there's other similar questions. Can we bring that slide back up of what is included in the definition of a home inspection in Massachusetts statutes? I think that would be helpful to answer that and a few of these other ones. A lot of other, okay, great. And then I'll go to the next one.
Okay. Yeah, actually, you know what? I'm going to go to the language of our contract because I think that's where the confusion might be coming in. No, the buyer doesn't have to conduct any inspections at all. They have the right to have the home inspected in accordance with the law by a licensed Massachusetts home inspector. And then our contract to purchase also allows them to have these additional inspections if they so choose. They could elect to have a water quality test and none of the others. They could elect to have an inspection that's not covered here because it does say the buyer has the right to obtain inspections of the premises or any aspect thereof. Now, they can't be intrusive. So one of the questions that comes up sometimes is foundation testing, crumbling concrete, an issue really now moving throughout Massachusetts. You can't do something like a core sample, but you could do a visual inspection of the foundation. But no, the buyer's not required to do any inspections at all.
A lot of questions about selling a house as is. Again, that's a term of the offer to purchase. That is not anything related to this disclosure. If you're only accepting offers on the property as is, terms of the offer to purchase, this is triggered before that offer is even made. So whatever it is, disclosure, 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 disclose it, get it signed, and then deal with all those other terms with the offers. And, even when you say as is, I'm sure you've all experienced people submitting offers with lots of new roof and something else coming on. So just keep in mind, those are two different things altogether.
Yeah, and I think that's important. That question does come up a lot, right? The seller's never been required to renegotiate terms, reduce prices, or make improvements to the house. What this gives the buyer is that contingency, which means the ability to walk away, withdraw from the transaction if they're not satisfied with the inspection. They may ask the seller, they may say, I've had this home inspection and it identified these items that are in need of repair. We'd like to renegotiate, or we're going to walk away, right? The seller can say, nope, I was told you up front, or maybe not, that this is being sold as is. Really, the home inspection gives the buyer the opportunity to find out what that home is as is.
a lot of questions about pre-inspections and then questions about enforcement. And let's talk about the 93A enforcements versus what is the seller held accountable to?
Yeah, I think we addressed the pre-inspections, right? Both from the seller's perspective that does not satisfy the law and the buyer. Yes, they can have a pre-inspection done, but they cannot then waive their home inspection in their offer. They still have to have that contingency in the offer. Enforcement is going to come from aggrieved parties. So you're going to have the buyer who buys a house doesn't have a home inspection, turns around and says, well, I never knew I could have a home inspection. Right. You've got your 93A claim against the listing agent because that disclosure was never provided to the buyer, notifying them of their right to have the home inspected. The regulations do also extend liability to the seller. And I think it's important to discuss this with your seller, that the seller needs to make sure that they are following the law so that they aren't opening themselves up to liability. And I think, it'll come through the courts because you'll have that aggrieved buyer who's going to say, I didn't know I could have a home inspection. Nobody notified me of it. I didn't have a home inspection. And now I found out that there are significant issues with the house, significant defects with the house that need to be remediated. And had I known that I could have a home inspection, I would have. Also, for you all, it would likely be reported to the Board of Registration, so the licensing board as well, and could jeopardize your license. So really important to make sure that this is being followed.
I'm going to pick out this one because it's unique and different. Let's say you've got a 4-unit project, not new construction, and the individual is selling all 4 units at once. Is there one disclosure or for the entire dwelling, or is it one disclosure per unit?
If the building is being sold as a whole to one buyer, it is one disclosure. If they are 4 individual units that happen to be being sold at the same time, but the deed is individual to those units, then you would need a separate disclosure for each one of those.
Okay, great. All right. There are 418 questions, which many of them I think are similar and have been answered. I'll just share. We will download all of these. Many of them are probably already on our website in the FAQ. Please visit marealtor.com. You can just type in the search button, the search up top, home inspections. It'll be linked as well. There's a great FAQ there. There's also a PDF you can download and provide to your sellers. There's also 2 new pages added for buyers and sellers and things that they need to know about this. There's a PDF available that you can download and put in your listing presentations to help explain this to your sellers. We are so happy to be as helpful as we possibly can with this new regulation and your implementation of it. The key is this is a disclosure. The key is the time of the trigger is the offer to purchase prior to the offer to purchase. So please keep that in mind. We are going to download the rest of these questions, add them to our FAQs. If you need anything else, we are always here at legal@marealtor.com. Our legal hotline. Reasonableness, again, it's relative to the rest of it. For those of you, and hopefully it's not many of you on here who have ever been part of a professional standards training, that's what the panel does. They judge the reasonableness of the action based upon the circumstances and the facts. So what might be reasonable in one transaction might be completely unreasonable in another. So that's something that will be determined per transaction. I hope this has been helpful. If you have any more questions, I already see some of you have emailed MAR@MA Realtor. Thank you so much for that. We appreciate it. And we will make sure that we get all these on our FAQs. Thank you so much for being with us today. I wish you luck over the next 2 weeks. Last year, we were here about settlements. This year, we're here about a disclosure. This is less invasive. So we've got this. We've got this. You've got this. Go out and be successful. Thanks, everybody. Thanks, Justin.